Welcome to Module 2, the institution as a legal entity and the role of the governance board. This week, we will begin exploring the authority and responsibility of colleges and universities, how that authority impacts institutional liability, how contracts are impacted by institutional liability, and the concept of sovereign immunity. Additionally, the legal obligations of governance boards will start our legal journey. As we move forward in the course, we will be looking at legal issues from a particular vantage point. Governance boards, student issues, faculty issues, staff issues, and outside entities. I want to make note of the fact that the legal issues we will be discussing this week are not solely limited to the groups we will be discussing. Rather, we will be looking at the legal issue as it relates to that specific population. The legal issues we will be exploring transcend the limited viewpoint we will be using for this course. So as a legal issues scholar, you are challenged to think about the legal concepts we will be exploring and how they may apply to different areas of the institution. This week, put yourself into the role of a member of your institution's governance board. What are the key issues facing our institutions? You will also be exposed to the shift towards compliance and risk management in higher education during your work this week. How are colleges, universities, and their agents able to do the things they need to do? They create policy, they take action, and they are responsible for the legal liability as we explored last week. They are able to do this because of authority. Authority is the right to take action and make decisions on behalf of an organization. And in our studies, that means institutions of higher education. Authority is traditionally granted through the recognition of a college or university as a legal entity, either by the state, if they're a public school, and articles of incorporation for private institutions. If institutions, or the individuals representing the organization, do not have the authority to act, there can be legal consequences for both the organization and the individual. Kaplan and Lee discuss 4 different types of authority utilized in higher education: express, implied, apparent, and inherent. Express authority is when the ability to act on behalf of an institution is written. Implied authority is implied that the ability to act on behalf of an organization exists for the organization or individual. Unlike the 2 previously described forms of authority, apparent authority is the belief that an individual has the ability to act on behalf of an organization when that individual does not have that ability. Lastly, inherent authority, which is not frequently used as a method of authority, is the belief that because an organization or individual was created or exists, that they fundamentally have the right to take action in the way they need to take action. This type of authority is often referred to in addressing safety or addressing disruptive behavior on campuses. As you work through this module, you will be exposed to the concepts of tort liability. Tort liability requires organizations or individuals to ensure that an individual is not injured if they have a duty. By injured, that does not just refer to physical harm. Injury can include anything that does not meet the duty towards a standard of care, and the harm caused is as a direct result of failing to meet that duty. As a part of tort liability, there is a concept which may protect certain educational institutions, as they may be immune from certain types of legal action. This concept is called sovereign immunity. Under sovereign immunity, if an institution is considered an arm of the state or an agency of the state, there are certain types of lawsuits that cannot be brought against the organization. Sovereign immunity varies from state to state and only applies to those organizations deemed to be an arm of the state. For example, in Florida, The Florida Torts Claim Act of 2011 does waive sovereign immunity for certain types of torts, such as injury or loss of property, but does limit the damages which can be awarded to $200,000. The sovereign immunity in Florida also extends to employees, which state, "No officer, employee, or agent of the state or any of its subdivisions shall be held personally liable in tort or named as a party defendant in any action for injury or damage suffered as a result of any act, event, or omission of an action in the scope of his or her employment or function, unless such officer, employee, or agent acted in bad faith or with malicious purpose or in a manner which exhibited wanton and willful disregard of human rights, safety, or property." However, sovereign immunity is not absolute, and the courts may make the determination that certain torts are not a part of the governmental role of the organization, and as a result, the institution may be liable. In contrast, negligence does not have the same protections as torts do for institutions and individuals. Negligence suits are not party to sovereign immunity with the courts. Negligence centers around the basis that institutions have a responsibility to protect individuals from foreseeable injury or harm. A major consideration for negligence cases in higher education is centered on the individual being an adult, whereas the standard that higher education institutions were founded on, of in loco parentis, with the institution acting on behalf of the parent, modern legal issues surrounding duty of care have shifted in the past 50 years to the thought that individuals are adults. That being said, institutions can still be negligent in their actions if they should have reasonably known about the danger. Negligence cases can arise from activities students participate in, premise liability in maintaining safe buildings and facilities, while involved in instructional activities, or in some cases in instances of self-harm. Bradshaw versus Rawlings, discussed in Chapter 3 of Kaplan and Lee, is a great example of exploring if an institution has a legal duty to protect individuals from harm while participating in an activity. In this case, 2 students became intoxicated at a student class picnic occurring off campus. One student injured as the passenger of the other student in a car accident on their return to campus. While the initial ruling found the university negligent, upon appeal, it was determined that the university did not have the duty to ensure student safety, and as a result was not negligent. For any individuals considering advising student groups or planning events, risk management planning to mitigate negligence should be considered. Another example of negligence case involving student harm is Shin versus MIT. Elizabeth Shin was an enrolled student at MIT. During the course of moving Elizabeth into her residence hall, Shin's parents shared concerns for their daughter's mental health with the university life staff, who implied that they would take care of her. In addition to the staff, Elizabeth was supported by the campus mental health services during her time at MIT. Ultimately, Elizabeth committed suicide in her residence hall, and her parents sued for breach of contract and negligence. While the case was dismissed against MIT, it was allowed to proceed against the administrators and staff. Ultimately, the case was settled outside of court for an undisclosed amount. Being aware of duty of care for administrators, faculty, and in certain cases student staff is an important consideration in mitigating harm as well. Additional forms of liability will be explored as you continue to work through this module. As we journey through the course, several cases of interest will be highlighted to explore legal concepts and rulings in action. When looking at torts, a recent example impacting a university community are the cases resulting from the Texas A&M bonfire tragedy of 1999. At Texas A&M, a university tradition existed dating back to 1909. The tradition was for the students to build a bonfire the week of the Texas A&M versus the University of Texas at Austin annual rivalry football game. The comment regarding the tradition was that the bonfire should be large enough so that it could be seen in Austin from College Station, over 100 miles away. By the time that this tradition reached 1999, the student-led event's purpose was to have students build a 59-foot tall wedding cake tiered structure made of logs on university property. Students would don their flower pot hats and overalls and come out to assist in the building of the structure. The university, administrators, and a hired construction company were all involved with this tradition. In the early morning hours of November 18, 1999, the bonfire structure collapsed, resulting in the deaths of 12 students and the injury of 27 students. In the multitude of lawsuits filed as a result of this incident, the families of the students injured named the university, the contracting company which provided the cranes and the crane operators, as well as individual student leaders and 4 administrators. The argument for the cases centered in the fact that the university and its officials created a dangerous environment for students and were deliberately indifferent to their safety by encouraging the unqualified and inexperienced students to build the enormous bonfire stack without adequate supervision by university personnel. In one of the initial cases, Kimmel versus Texas A&M, the university argued that they could not be subject to a lawsuit due to the state laws involving sovereign immunity. Initially, sovereign immunity was granted by the district court. Additionally, the charges of deliberate indifference against the administrators based on a due process claim that the students had a right to safety and that there was state-created danger by the administrators. The district court stated that there was insufficient evidence for the due process claim and dismissed the case against the administrators. In the Texas District Court of Appeals case of Scanlon versus Texas A&M, both the sovereign immunity and deliberate indifference decisions were overturned, and the case was remanded back to the district court. On remand, the administrators requested and were granted a summary judgment, which granted the administrators qualified immunity in the suit, as their conduct in their roles was deemed to be not objectively unreasonable based on their duties. Ultimately, the court cases with the families were settled by Texas A&M for $2.1 million in 2008. As future higher education leaders, being aware of the sovereign immunity laws of your state if you are working at a public institution, as well as the recognition of your possible liability as an administrator, leader, or advisor, are important considerations to explore as you take on new roles and responsibilities. One of the groups at colleges and universities charged with maintaining the mission, vision, and path of the institution is the Governance Board. Oftentimes referred to as the Board of Governors or Board of Trustees, these groups, comprised often of individuals from the community associated with the institution, are charged to provide governance to higher education institutions. While there is shared governance with the president, faculty, and other constituencies, governing boards are legally responsible for their fiduciary duties to the institution. Fiduciary duties for board members mean that the individuals must act in the best interest of the institution they are serving, independent of any financial or other gains they may personally receive. As a result, conflicts of interest from a legal perspective are important considerations when selecting and vetting possible new board members and current board members. Based on business or personal relationships, an individual may have a conflict of interest which could put the institution and the individual at legal risk. As a part of your work this week, you will explore the role of a member of a board of governors or trustees and consider what information from a legal perspective should be shared during board training. Additionally, this week you will be exposed to the concept of Compliance U. Peter Lake, a higher education legal scholar, describes the transition of institutions of higher education to those of being compliance-driven entities reacting to the additional state and federal mandates and legislation which impact the daily functions of the administration, faculty, and staff on campuses around the country. Compliance is described in a risk management framework and is a legal issue which should be of importance to governance boards as a part of their duties.